Hi, I'm Sara Clark, and welcome to OSBA's Legal Ledger Sidebar. I'm joined today with John Price, and we are going to be talking about Ohio's Open Meetings Act. And the sidebars are part of our Legal Division weekly blog, where we talk about hot topics that are relevant to school board members across the state. John, thanks so much for joining me today.
Hello, Sarah. Happy to be here.
Great. So the Ohio Open Meetings Act has been around for a really long time, and generally what it does is it requires public bodies in Ohio to conduct their official business in open meetings that the public may attend and observe.
Right, so it seems pretty straightforward, but it is something that we actually get a lot of questions about from members on the hotline, and it's a common topic that comes up in litigation, so it's really important that our members understand it and get it right.
Yeah, we do, like you said, get a lot of questions on the hotline about this. So let's walk through some of those questions that we get, starting with the applicability of the Open Meetings Act to board committees. And I mentioned at the start that the Open Meetings Act applies to public bodies, and that not only includes the board itself, but it also can include board committees and those subcommittees of the board. So the definition of public body under the statute both includes committees and the subcommittee. So what does that mean for school districts? It means that some of those Open Meeting Act requirements, the ones about noticing their meetings, about making those meetings open to the public, and keeping minutes apply not only to the board itself, but also may apply to some of those committee meetings as well.
Right, and I think something that's really important to keep in mind is that this is true regardless of how many board members are actually on that committee. So if the board actually created the committee, it doesn't matter if there's one board member on there, 2, 3, or 0, it's still a public body, which means that it's subject to the requirements of the Open Meetings Act.
That's right. And back in January, we actually wrote a blog post that provides more information about this topic, including some of the things that you want to consider or walk through to see if your committees are subject to the Open Meetings Act. So I'd encourage you to check that out.
So just to switch gears a little bit, I want to talk a little bit about some other events or quote-unquote meetings that board members may attend where a majority of board members may be present, but it's not what we would consider a board meeting. So something like a community forum or a levy committee or something of that nature. How does the Open Meetings Act apply to those situations?
Yeah, this is a great question, and we've gotten a lot of questions this time of year too about things like candidate nights because it's the season for elections and things like that. So Open Meetings Act, it defines a meeting as a prearranged discussion of the public business of the public body by a majority of its members. So if you've got a meeting where a majority of your members are going to be in attendance, this is something you want to think about, and you want to be asking yourself what role those board members are playing at the meeting. If they're just present as observers, they're not discussing board business with one another, then it probably doesn't meet the definition of a public meeting under the Open Meetings Act, and those rules and regulations that apply to meetings under the Open Meetings Act wouldn't apply. But if they're discussing board business with one another, or they're deliberating with one another, then it's possible that there's going to be an Open Meetings Act violation. So conservative approach is to have fewer than a majority of your board members in attendance at those meetings, just to be on the safe side.
So, as I'm sure you've noticed as well, there's been a lot of increased scrutiny around meeting notices, and we know that the Open Meetings Act requires school boards and other public bodies to establish by rule a reasonable method whereby any person may determine the time and place of a regular meeting and then the time, place, and purpose of all special meetings.
Right, and the district can choose which reasonable method it uses, right? So that could be posting a notice on the district's website, it could be making an announcement in the newspaper, posting something at central office or in the community center. The key thing to keep in mind here is to determine which method is most likely to reach the public, to identify which method, or identify that method in a board adopted rule, and then consistently provide notice of those meetings through the method that you pick.
Yes, I agree. Good advice.
Okay. And John, I think we're going to wrap it up with that. So this is an area of the law where we do get a lot of questions, and we have a tremendous number of resources for districts. So if you have a question or you're looking for something that you can share with other board members or community members in your district, just reach out to us and we'll be happy to pass along those resources. So John, thanks for talking to me about this, and thank you all for watching. We'll see you on the next sidebar.
See ya.